happens. Okay, so I think it has passed our start time, so I think we can get going. And people who join us afterwards, I think will be pretty easy to catch up. Okay, all ready, Francesca?
Yeah, I will start sharing my screen. Just give me a sec. Okay, are you seeing my screen now?
Mm-hmm.
Okie dokes.
Good.
Cool.
Okay, so hello everybody, our audience members. We are thrilled to have you join us today for the beta launch of unlockbailreform.ca. The site is live right now. We're going to walk you through it, but you can also click around during the presentation. This event has two parts to it. The first 30 minutes, Francesca and I are going to talk about the project, how we got here, the goals of the project, kind of what's next. And then we're going to have our panelists, which is the big highlight. And I'll introduce them once we get to that point again. So I guess we better just start with introduction. So my name is Avery. I'm the director of the Law and Design Collab. We're a nonprofit. It's entirely run by volunteers. And what we do is we unite professionals from creative industries in design, tech, and creative communications and strategy with leading justice advocates to develop communication products. And we formed this group in 2017. We've been working for a couple years now. We worked a lot with legal information, and now we're kind of doing a bit more on the advocacy side. And Francesca is our design lead, and she's also a graphic designer.
Yeah.
Okay, next one over. So this is our team of fantastic volunteers. A huge shout out. These people have been working on this project for the last year. Everyone's kind of come on at different times, and we're just so grateful for the talent that's come out. And I think it also shows the level of interest in the tech and creative communities to work on social justice projects in a meaningful way. And I will speak to that a bit more about where we see this project going and how we can keep involving creative professionals. Okay, Francesca, I'll hand it off to you to
thank you. So before we actually move to show you the actual website, we'd like to set the context for this project a little bit and bail reform as a topic. So this year, more than ever, justice communications are in the spotlight. Everything that's happened since the last spring, of course, with main focus in the US, but it has expanded with protests and movements. It's generated unprecedented momentum for social justice related topics at a global scale. And we've seen both traditional media and more modern one being taken over. So while the US certainly is a unique case when it comes to criminal justice policies, think of their bail system or mass incarcerations or police brutality, they are also an inspiring case and unique in this sense when it comes to effective justice communications. I don't know why it's not moving to the next slide. Sorry, guys. Technical issues.
Oh, I think it's just a bit of a lag.
Yeah, okay, here we are. So I was saying that the US represents an inspiring case when it comes to effective justice communications. We've seen a new generation of advocacy being born, one that has clearly a strong media presence on digital and social media, and a very well-defined creative vision. And most of all, it's backed by a very powerful and well-funded philanthropic sector, which means that they can invest in creative partnerships and put out projects with very high production value. Unfortunately, we cannot say the same for Canada. This kind of advocacy has a smaller scale. Traditional media channels still have a very prominent role, which means like TV and newspapers. And nonprofits and philanthropic organizations don't have the same size or power as the ones in the US. Plus, if you consider the fact that whatever happens in the US easily crosses the borders in terms of resonance, and so take away a very big share of the attention. And finally, the advocacy culture is basically different. The one in Canada is clearly more timid. All of it creates the fact that justice communications only get so far in terms of results. And that's why we think there's opportunity for this new generation of advocacy to be fostered here in Canada as well. So now we should probably expand a little bit on why we chose bail as a topic, bail reform. Bail is considered to be the single most important stage in the criminal process. Whatever happens at this stage has profound impact on the outcome of the case itself. Think of people falsely pleading guilty just to get out of jail, or whatever these people lose while on bail, social ties, housing, a job, very simply. Ontario in particular has a bad track records when it comes to bail and marginalized people. So Black and Indigenous people are overrepresented by 300 and 500% respectively among remand prisoners. And finally, the attempts of legal advocacy to reform the system haven't had consistent results throughout the province. So I'm sure our panelists will expand on this later, but all this make bail an ideal issue for social communications. Extensive research, strong consensus on what bail systems flaws and possible remedies are, and the fact that all experts agree on the fact that shifting the public's perception would have a major impact. And all this make bail reform an ideal issue for approaching it with creative-driven communication strategy. So Avery, I will leave it to you to explain our project.
Great, thank you, Francesca. Are we on the next slide? I'm trying to figure out. Okay, great. So where, what is the collab? What's our role in this? The way that we see our work is to use creative media to give expert knowledge the cultural influence and resonance that it deserves. So we see ourselves as this little bridge in our clip art here. And this collaboration is where we're directing it is to produce these artifacts and experiences, generate unprecedented levels of engagement is our goal, of course, and shift culture for systemic level change, which is what's needed. So next slide.
A bit slow, sorry.
Yeah, that's okay. Okay, so I just wanted to give kind of an overview of how this project has developed and where we are. So this is starting last year, Q4. We were scoping out this project, had a design hypothesis, did a lot of extensive interviews with experts. So I just have to close my door here. Otherwise we might get some baby noise. Then in January, we recruited creatives and held a design challenge. And a huge shout out to the Law Society of Ontario, especially Sheena Weir and Chloe Hill, who have done so much to enable this project. And so we held this creative design challenge at the Law Society. It was a really great event. We had over 30 creative professionals come out. And this is kind of where we had a lot of these, the core ideas for this project came to the surface. And from this emerged our website concept. And then through Q2, Q3, we were building the beta, which we're going to talk about today, recruiting partners, some of whom you're going to speak to on the panel, and we'll speak more to this brand architecture and the scope for a creative campaign. So looking to the future, today we're launching the beta, and we're seeking feedback from the legal community, which is a lot of this audience right now, as well as the creative community. We're currently in discussions with large advertising agencies to kind of come up with a creative campaign for 2021, and we will definitely keep you posted on that. So next slide, Francesca. Okay, so creative strategy. So thinking about 2021, like what this website is kind of the centerpiece of our campaign, but what are we exactly thinking about doing? So we don't have exactly all the time to get into this, but I thought it would be helpful to kind of speak to the core creative decision making that's going on right now at the collab. So first is to consider what are the successful projects in the US that we are really being inspired with, and I really highly recommend that you guys check these out. This is the Bail Project, In Defense Of, which is from the Brooklyn Defenders. mapping pretrial injustice, a really comprehensive website for advocates in the US, and Justice Not Fear, which I think is the Chicago version of a previous campaign. So when we're thinking about how we're going to, kind of what strategies and tactics are we going to use, we really have to think about our theory of change. You know, what audience segments are we targeting? How are we going to be engaging them? What actions do we want them to take? And also, because this is a systemic issue, it's not going to be an A to B path. You know, we have to be attentive to emerging trends and seeing how stakeholders respond, because as we'll find out, that's a huge part of this problem. And then in terms of tactical choices about like how to communicate, and we're going to talk about this a lot as we walk through the site, we're balancing some really fundamental tensions, right? Like, how do you speak about this topic in an accessible way, but not reductive? You know, how do you speak it in a way that connects with people and is not overly abstract? And then a really interesting tension we've been dealing with is, to what extent are you trying to confront people with a disturbing reality and kind of shock them out of their complacency? But on the other hand, that may not be necessarily a good way to motivate people to act, right? So you may instead need to inspire people or invite them into a conversation so that they can see themselves reflected and being kind of like the heroes of a story. So these are all kind of things that we're struggling with. Next slide.
I think we are
ready to go.
Yeah, let me.
Oh, I think it's the content one, the schematic.
Yeah, sorry guys, just a sec. I don't know why it doesn't respond to my comments.
Right.
Yeah, here it is.
So before we open the website, I thought it would just be helpful to first kind of explain the structure of the site. So it basically is a collection of 6 pages, and each has a kind of a different concept. So first is, of course, the landing. We have the stories, and these are human interest stories about the human cost of the bail system. Ideally, these would be videos, but you know, with our limited budgets, we're doing interactive scrolly telling right now, as you'll see. A system map, so this is a visualization of the bail system. Explanations, a kind of like a explainer style. Again, video would be an ideal medium for this, but we've kind of done our best with what we have. And then a timeline which puts the issue in context. I mean, that's kind of the thing, is we really want that expert knowledge to come through. There's been so much good work done on this, and we need to build on that work. And then finally is the call to action. Okay, I'm done talking. So let's open the website. Oh, wait, that's me, right?
That's you. Yeah, I'll stop sharing my screen. And it's you now.
Okie doke. Okay. So this is the website. It is now live, so you're welcome to explore. So Francesca, I'll let you speak to the kind of some of the design considerations that went into this visual.
Yeah. So before we delve in depth into the single components, I'd like to talk about the general branding that we decided to go with. We, of course, did some research on the existing projects in general on social justice issues, and we realized that there are a few trends happening, most of all, and you've probably seen from the few examples that we've shown in the presentation, that the pairing of red and black, like very stark contrast, a dark feeling, heavy, that is the main trend happening. And while we for sure got inspired by a few of these projects that we've seen, we also wanted to steer away a little bit from that kind of aesthetic. We want to, the same kind of balance that we've tried to achieve with the content of our website, we wanted to achieve the same thing with the aesthetic and the branding. And so while you see that black and a hue of red have a role in this palette, of course, we wanted to have also bright colors because we want to balance it with also a positive and hopeful approach. I'd like to mention our main font for a sec, just because this huge font that you see in this first screen, it was designed recently by a foundry in the US that's called Vocal Type, and it recreates the typeface of protest posters used in Memphis in 1968. And the foundry itself is very invested in advocating for diversity in the design industry. So it's a little bit meta here. more in general, we wanted to have a visual language that's definitely serious as the topic requires, and polish, because we didn't want it to be too funny, cartoonish, but at the same time, we wanted it to be approachable and inviting, and something that the user finds pleasant and can, doesn't get tired with. That's the thing. Also, because we have 4 main components and it takes time to go through all of them. And our main hope, of course, is that users do that. Mm-hmm. So if you want to just like scroll around and then move
so
to
this
the
is
stories.
As I mentioned, these are kind of the landing page and the different features. And then these are the explainers. So let's start with the stories over here. Okay, so this user interaction is called in the creative community scrolly telling. You may have seen it on websites like New York Times, other kind of investigative journalism places like ProPublica. So basically, as you kind of move your cursor down, it's a more engaging way to kind of absorb content. And we've also, these are actually 3 short stories. They're all based on, they're true to life. So they're facts that we've taken and put together in a short story, either through court cases, reports from the Ontario Human Rights Commission, research reports, all different sources. And the goal is that these stories are plausible and that they are fairly representative of the system as it is in Ontario. I'm not going to go through these points, but I just wanted to show you that we did think that there would be some use for user interactions. This is not like a choose your own adventure idea. There are interactions, but it's really just in service of the overall story. So I'll just kind of scroll a bit further. Did you want to speak to some of the other design considerations, Francesca?
Yeah, just briefly, I think you explained everything about the scrolly telling. I think we can say here that we use, as you are seeing, black and white photography treated with a halftone filter and then our color palette. I think it gives it some kind of news media feeling in terms of visuals instead of having like icons or illustrations. And also, I think it makes the user feel like even more that these are true to life stories, because it can put in relationship faces and the content and then the background, everything concurs to give the right feeling and the right tone with the text that's in the content.
Okay, so I'm gonna move on from the stories now. I will kind of add that we are seeking feedback from the legal community on this entire concept. If you think this is a very misconceived idea, let us know why. Or if you think that our plot points could be better, we could highlight different parts or different parts of the system. There was obviously a lot of editorial decisions that went into this, and we're by no means at our final product. So this is the system map. And it's an interactive visual map that is supposed to give people a kind of a bird's eye view of the system and introduce people to how the system works. So we have our dramatis personae here. And this is, maybe I'm gonna zoom in a little bit. Here we go. So as the user scrolls here, this is the first layer of the map. And again, this is a simplified map. We did need to make some editorial decisions about this. The user is able to kind of click on each of these stages to see what's happening essentially in these stages. The next thing we wanted to highlight was the decisions that are made. So here's an example here: the decision by police to lay charges and require a bail hearing. What's being decided, how it's being decided. Again, like for the content here, we are very interested in the feedback from the legal community. As with a lot of things, it could be amazing. We could have like a glossary. We could have, all these other features, but we're trying to keep it within like a minimum viable product range. And then finally, we have these systemic problems. So for each of these decisions, we have some analysis into kind of what goes wrong. Let me see if this one is the one here. So like inconsistent decisions, unreasonable bail plans, questions that the audience should be asking. One of the goals here is to provoke thought. It's not necessarily to deliver a very technical or academic explanation. Francesca, did you want to add some comments?
No, I think here we wanted to prioritize the interactive experience in comparison with the stories that are more like passive as an experience for the user. And the great thing I think of creating this website was also that each of these components can be browsed and experienced on their own, but they are also functional to the browsing of everything else, because of course, if you go back to the stories after you've seen the system map, you probably have more context in terms of what the technical aspects of the bail system are.
Mm-hmm. Okay, great. So then the next part is these explanations. And actually, maybe let me just go back to the main page here. This is how is our bail system broken? So this is essentially like our attempt to create pithy slogans that are actually not oversimplification, not overly reductive explanations, since we think that's actually a big problem in public media. So we still created a kind of a visual identity for each of these explanations, but we do want to delve deeper. So here we kind of have a description of what is going wrong from a systemic point of view. We think it's really important to highlight the achievements of advocates, journalists, researchers working in this field who have made a lot of progress. And we would like help, again, from the legal community in identifying the most impactful programs for that kind of fall under this theme. So you can see that we've kind of identified a few. This user interface concept, we can definitely iterate on to make it even more user-friendly for people who are not already kind of deeply involved in this issue. Then we kind of talk about the opportunity for creative media to make a difference. And then this is our explorable explanation. So Francesca, maybe you want to speak to how you kind of arrived at this design.
Yeah, so this was, I think, the most complicated piece of our project. There were a lot of iterations on this, and we ended up basically recycling the diagram from the system map so that the users can see something that they should be familiar already with because they've explored it in the other page. And it's almost as if we zoomed out a little bit and we created this context for each of the three themes. And so there's a layer of interactions in the sense that there's still this scrolling trigger. So while the user keeps scrolling, something happens on the screen. And so we are trying to create a relationship between these items and expand on them on the right with the supporting text.
Mm-hmm. Yeah, and again, like these are, this is our best effort to really delve into the systemic causes of these problems. And these are factual explanations. I think these are all very well justified in the research literature. Again, this is not like conducive to an academic paper type presentation, though we have included some sources for people to kind of get some valuable statistics. So I'll just kind of walk through the other themes, and there may be questions, I guess, about some of these themes as well. So here, this explanation, for example, talks about how insufficient funding for legal representation and harmful prison conditions combine to lower quality of defense that an accused can mount, which then has repercussions on the rest of the system, kind of the outcomes that they get, which then kind of pulls down their socioeconomic conditions and puts them back into contact, more likely to be involved with criminal activity. So by the opportunity here is by adding funding to the system that's adequate, we can kind of undo these really harmful ripple effects. And the last one, which we're definitely going to cover in the panel, is a culture of fear, a culture of risk aversion in the system. And that is, due to public perceptions over time have built up certain kind of biases in decision-making at key points in the process. And that, over time, this is a lot of cultural inertia that is very even difficult for legislation, difficult for the Supreme Court of Canada to fix by their decisions. And so there's definitely an opportunity for media to shake some of these cultural, entrenched cultures. Okay, so that's basically it. Oh, wait, sorry, no, the timeline, and I'll try to speed up here. I had mentioned that we have a timeline of essential research. So this UI concept, Francesca, maybe you want to speak to,
yeah. So we had this very wide amount of resources, and we could have done a very simple bibliography, but we thought that there was a chance here to add some layers of information. So divided them in categories and showing them year by year, but mainly putting them in context. If you see on the right, we have events happening in each of the years. So we are putting them in context. Plus the user can decide which layers to turn on and off, so they can only explore, if they are interested in one specific category, they can explore just that. And so it's basically more of a data visualization piece rather than a bibliography. And so we thought it was an occasion for us to show our methodology in a creative and engaging way for the users, especially for users that maybe are not used to do research and browse resources. This could be a more interactive piece for that kind of audience as well.
Mm-hmm. Yeah, thank you, Francesca. Yeah, so I think you guys get you get the overall concept here. There's definitely things that we could do differently with annotations. We have kind of related documents, because a lot of these, a single kind of court case can have a lot of media coverage. It's very relevant, so we wanted to include that, but not kind of destroy the UI, the clean UI here. And then we also have some kind of context, some political context going on the right side. So I guess to wrap up, this is our call to action. I mean, in our creative campaign next year, this won't be a beta, and so there'll be actually some kind of different call to action for members of the public. But for you, this audience, legal community and creative communities, we are very interested in your feedback. This beta is for you. So we have here a feedback form. You can also join our mailing list if you're interested in volunteering with us. We are seeking volunteers all the time. Or if you're interested in supporting our creative campaign going forwards. So this feedback form, just so you know, everything is optional here. You can be anonymous, it's totally okay. And if you want to provide even more detailed input, we have other ways to do that as well. Okay, I think we're on time, 2:28. So I will stop. Actually, I'm not going to stop sharing. I'm going to keep this going here. Okay, so we are ready to move on to our panel. 1 second, I see some questions here. Okay, interesting. I think that we will probably address these in the Q&A. Sorry, I don't have time to look at it all. But Francesca, if you just look at them and kind of send me the ones that we can address. Okay, so we're going to start with the panel now. So Boris, you can turn your camera back on. And unmute.
I'm sorry, I thought I had done that already.
Okay, so Abby and Promise, you're welcome to unmute as well, unless you want to kind of keep the background noise out. Okay, so we're thrilled to have Abby Deshman from the CCLA, Promise Holmes Skinner from Promise & Co, criminal defense lawyer, Jacqueline Tasca from the John Howard Society, and Boris Bytensky, who is also a named partner in his firm and is also works with the Criminal Lawyers Association. So what the format that we're going to do is we're going to have the panelists speak for 5 minutes each, 5 to 6 minutes on some kind of key themes that we kind of discussed in advance. And then we're going to kind of open up the floor for questions and have a more open-ended conversation. We'd love to kind of take questions from the audience. So I thought that we could start off with Abby giving some perspectives on her long-standing work to advocate for bail reform.
Thank you. So first of all, thank you to Avery and Francesca for inviting us and gathering us here today. So it's wonderful when you're like off in your corner doing work and you think, oh, wouldn't it be great if somebody who's better at web design, graphics, communications, like takes this and does something amazing with it. And then you go off and do other things. And then you turn around and you say, oh, it happened. So it's wonderful that you guys have been working on this. I'm excited about what you're doing and the impact you can have, and just thrilled to be here. So bail, right. So it's not that long standing that I've been working on this. You can talk to others who've been doing this for much longer, but we did in 2014 do a report with Professor Nicole Myers on bail and pretrial detention. And many who are listening today may be familiar with it if you've are invested in bail reform, but we observed 196 bail court appearances across the country over the course of a few months, and not a single person was released without restrictive conditions. We do not see a single unconditional release on consent or on a contested basis from bail court. And along with a whole series of other really problematic findings and trends, this the basis for our conclusion that in Canada, the law of bail was really not being applied regularly in bail courts. And I can speak to why bail court is a particularly difficult place to have an equal plane and an equal adjudicative forum, why people feel a lot of pressure to agree to very restrictive conditions just to get out of jail. It makes a lot of sense. And since that time, there has been a lot of action in the bail area, right? We have multiple Supreme Court decisions, Antic, Myers, Zora, Riley, as short as it is. We have policy changes at the provincial levels. We have lower court decisions, Balfour and Young, which are really very powerful. And we've had criminal code reforms, right? Bill C-75 was supposed to be a really major piece of legislation, in part in response to a lot of the problems that we and advocates and Supreme Court and John Howard Society Ontario were all raising. So where are we now? That's something actually we are trying to figure out. So we at the CCLA, we've started a follow-up funded thankfully by the Canadian Bar Association. So we're redoing the bail court observations that we did in 2014 to try and see, using our last report as a baseline, how have things changed? Have things changed? But I will give my current suspicions grounded in anecdotes and conversations more than the bail observation data, which I hope will come. But when we saw the Bill C-75, and you can go look up our submissions to the Legislative Committee, we were quite concerned that it wasn't going to be enough, right? Bill C-75 had a lot of great language in it, but this was language that we already knew, right? This is language that was drawn from existing cases, longstanding principles already written and read into the criminal code, and our constitutional rights did not really give us, a shakeup of the law. It confirmed what the law was, which is good, because a lot of bail decisions weren't following the law. A lot of releases didn't look like the way that the bail system was designed. But when the big legal reform is to restate what the law is, and the underlying problem is we have a culture of risk aversion, adjournments, and delay, and really inattention to the rights of the people who are sitting in jail, that's not going to be enough. So that was our concern. And I think, based on what I've been hearing, COVID has thrown all kinds of things upside down, sideways, and backwards, and whatever. And I think Boris is going to talk a bit about that as well. But just in general, I think we're hearing that it hasn't been a sea change in how bail courts are operating. Certainly, there have been some changes. Those adjudicators, justices of the peace, the Crown, that were attentive to the legal framework and the rights, and they've changed their practices. Those who weren't to begin with, those who thought they were applying the law before, continue to believe that they are applying the law in a lot of ways. So that is the we'll see. You know, I am eager to be proven wrong. But I do fear that we are not done pushing for federal legislative reform and hopefully, you know, more fundamental changes that would actually signify a really significant shift in culture and practices in bail courts. Is that about 5 minutes?
Yeah, perfect. Like on the spot.
Oh, there we go.
Great. Thank you, Abby, for providing those perspectives, and we'll definitely follow up with some questions for you afterwards. But let's now move on to Boris, who will speak to COVID-19 and your other insights into the bail system.
Thank you, Avery, and thank you, Francesca, for having me. I share some of the same thoughts that Abby does. I have had the good fortune to be involved with a number of important bail cases over the years. Balfour and Young was a tragic and heartbreaking case, and perhaps as important a case as I personally litigated in my career. And the more recent case of Riley, where I appeared for the Criminal Lawyers Association at the Supreme Court. I'll just mention briefly, as it ties into what else I'll say, is I see that as an opportunity missed by the Supreme Court of Canada to talk about the issue of bail delays and to set some wide-ranging good obiter dicta that the rest of the country could have used. One of the things I was asked to comment on, and I will, is sort of the impact of COVID. And when COVID caught us all not very ready to deal with criminal justice in the time of a pandemic, there was a lot of scrambling, as many people who are watching this will know. There was a motivation to get as many people out of jail and out of our courts that was born out of necessity and born out of real legitimate health concerns about having our jails overcrowded, needing to get those numbers down. We did see more people get out probably than ever before. We saw some very liberal bail positions being taken through the courts and by the crowns. I think there were more people, I don't have the statistics handy, but I think there were more people getting released by the police than ever before as well. It seems that the times are changing back closer to where we were pre-COVID, even though we really haven't beat all the challenges that the pandemic has brought. I think the attitude that dominated bail courts over the first couple of months is waning. Could be a combination of COVID fatigue, or it could be simply a leopard reclaiming the spots that disappeared for a period of time. The other possibility, of course, is that the delays that are inevitable when you're dealing with so much tech and so many procedural short-term problems that we have, it just means that more and more people are languishing in custody waiting for bail hearings than perhaps ever before, and that was already a big problem to begin with. So the numbers went drastically down in terms of the number of people being released from jails. They're creeping back up. They are not at the levels they were pre-March 2020, but they are not also at the levels that they were in June either. So it is both something to be aware of and something to be worried about to some extent. Some of the tech improvements that we've seen are here to stay. We can complain about the problems of virtual bails until we're blue in the face, and frankly, I'm one of those people that sees much more good about video hearings than bad, and I'm generally in favor of them, subject to some particular comments that I may see. I do worry about audio bails, which are very prevalent. I do worry about some of the injustice that falls from that, but I realize that in the time of the pandemic, we really don't have a lot of options. So hope that those things aren't here to stay and over time. But the biggest issue, and I'll sort of end with this, the biggest issue is bail delays. They've been an issue for nearly 20 years that I've been deeply concerned about and have litigated. They remain an issue. The pandemic has made it worse, but the attitudes have not changed enough. Criminal justice is, as others have said, a risk-averse area to begin with, and bail is particularly so. There is a great deal of inertia, and finally, and most, I guess, most upsetting to me, is that too many people in the criminal justice system, including defense lawyers, definitely including crowns, don't really pay attention to legal developments. So whether it's changes to Bill C-75, which, as Abby said, don't really change the law that much, just codify it, whether it's important decisions from as high as the Supreme Court of Canada, the people on the ground who do bail hearings do not really get the message, or certainly they don't get the message very quickly. In my experience, it doesn't happen often enough, and I include defense lawyers when I lay blame here, because we are all of us who are involved in bail courts, often too content to do what we've always gotten used to doing and do whatever we can to try to get through the system as quickly as possible because of the inevitable bail delays. And it's that inability to proceed quickly that generates so many of the other problems that we have. So we must address them. We must find solutions. One way is to limit cross-examinations, for example, of sureties. And there are some conflicting decisions from earlier this year about what that involves or what that might look like. And I don't have time right now to get into it, but I'm happy to do that later in the Q&A if people want to discuss that. But I think we do have opportunities to make our bail hearings and our bail system, if you will, more efficient. And frankly, until we do, I'm not sure that we can solve the rest of the problems all that easily, because that is the leverage that defense lawyers don't have and Crown's lawyers do have. The threat of having people stay in jail waiting for hearings, that happens all the time, that guides so many of the other decisions and so many of the other steps that end up playing themselves out in the bail hearing context. We fix that. We fix a lot of things. Anyways, those are my 5-6 minutes, and I'm happy to talk further in the next phase of this presentation.
Perfect. You're all like Swiss clocks.
These are pros, Francesca. Thank you so much for sharing your insights, Boris. Yes, like we'll definitely follow up on some of those points. So let's move on now to Promise, who's kind of speak to how cultural change has or has not kind of spread through Ontario.
So when we say cultural change, we mean about bail, obviously not cultural change of like Indigenous culture making its way actually into the courts. I don't think anybody's going to think that that's actually happening. So I'm Anishtabek, and I represent a lot of Indigenous clients, and I work all over Ontario. And so a couple things to what Abby and Boris were saying. I agree that not a whole lot has changed since the CCLA's paper on bail. And since the Supreme Court decision in Antic came out, I think that was a huge move. And I can say that I've seen differences in some places and not any differences in others. And that's an issue. So like when I started, I was a second-year law student, and I started at College Park in the duty counsel office. And then I stayed there as a per diem duty counsel in the Glue court only for like a couple years while I did other work at Aboriginal Legal Services and stuff. So I was seeing bail like every day since I was a student, and then every week since after that. And it did seem like almost overnight, Antic changed the way that, for example, College Park was doing bail. And I can also say that like in Brantford, they are forward thinking when it comes to bail. But places like North Bay and Cayuga, where I do practice too, feels like I'm in 2012. And it's very frustrating. And it's very upsetting because it does feel like there's a lack of direction from whomever is supposed to be imposing the direction. And it feels oppressive because we know information that we can use to move forward. And for whatever reason, decisions are still being made that aren't consistent with the law that we're aware of and the rules and like incidences of systemic discrimination and higher incidences of incarceration. It seems that in certain jurisdictions, and I know this is the case in places more north than the near north, that the over-incarceration of Indigenous people just is not a concern for people. And this brings me to my other point, which is about the tertiary grounds. So Jill Rogan touched on this in a paper that she wrote a long time ago that was referenced in the 2014 CCLA report on bail. And she alluded to the notion of, she didn't allude to it. She's talking about tertiary grounds, okay? So tertiary grounds is when essentially we as defense counsel have to prove that it would not shock the public's conscience if our client was released because they did something that is upsetting. So maybe they had a gun involved, okay? Something that the public is going to be upset to hear that someone is charged with. So we have to show that it's not going to shock the public to release the person. But what Jill is arguing, and which I tried to bring to the Supreme Court in another case that they didn't grant leave to, is that what we know about over-incarceration rates of Indigenous people, what we know about systemic racism about Indigenous people, what we know about the fact that incarceration contributes to recidivism. We know that incarceration of Indigenous people, it is detrimental to their healing and their rehabilitation. And rehabilitation isn't really a word you want to use when it's a bail stage, because innocence is, assumed. But healing is important because any interaction with the justice system is traumatic for lots of people, and especially Indigenous people. So what we know about all of that, the argument is that the Crown should actually have to prove that it wouldn't shock the public to detain the Indigenous person. So if they want to detain an Indigenous person, if you're thinking about the same member of the public that's already referred to in the code and in St. Cloud, like, would that individual, that member of the public, be shocked to learn that you're trying to detain an Indigenous person who stole from the LCBO again? So that is a way that we can be looking at the tertiary ground, especially in light of COVID, because the courts consistently and Crowns consistently acknowledged that detention just isn't necessary to protect the public. So a bunch of people, as Boris said, and I know, and like from doing tons of bail hearing, then and beforehand, I can compare the difference. A ton of people were released that would never have been released before. And even courts have, like they said it, COVID is really playing a role in my decision to release you. So we know that really the public isn't at real risk. Otherwise, those people would not have been released. So if the courts are prepared to consider new information that suggests that more harm could be caused by keeping an individual in custody than releasing them because of COVID, then I would expect that the same exercise can be used to understand that more harm can be caused by keeping Indigenous people and other folks in custody than releasing them, especially when it's resources to heal and to address the underlying issues that is related to the person being in contact with the system. And even if those underlying issues are being targeted by police, resources to deal with that stuff exist outside of institutions. So we already have been faced with the reality that there is a virus that was affecting the country and affecting the system. Colonialism and those effects are a virus affecting the country and the system. And we have information to show us that there are alternatives. And I'm hopeful that folks will be open to this kind of thinking moving forward, since we've had COVID to use as a good example.
Thank you.
Thank you, Promise. I think that's such a fascinating strategy for the tertiary ground to cut both ways, and kind of building on the practice that's developed in COVID. We're definitely going to speak to racial justice in the questions. We already have a question from Nye Thomas from the Law Commission about this. So thank you, Nye. We saw your question. We'll definitely get to that and explore it. So the last speaker, Jacqueline Tasca from the John Howard Society of Ontario. They do amazing work providing services to people who are in prisons, and they also are a powerhouse in doing research as well. I encourage you to check out their blog and website, just like all of our speakers here. So sorry, Jacqueline, that's the intro. So please go.
Oh,
ahead.
That's perfect. That's perfect. Thank you, Avery, and thank you, Francesca, and everybody for joining today on a Friday afternoon to talk about bail. So as the only non-lawyer panelist, I thought I would bring some, social scientist perspective to the issue of bail reform, and how we can actually continue to build on the gains that we've had recently, and how research and data and partners like JHS can sort of work in lockstep with legal professionals like yourselves in order to sort of continue to build on the law reform that has happened, and continue to ensure that there's fairness in the bail system. So a bit about John Howard Society. I'm sure probably most people on the call are familiar with us, but our local offices do deliver a wide range of services in the community, including the bail supervision program, and a couple of our offices also deliver bail beds. Provincially, we do research policy work, advocacy, public education. We've been focusing on the issue of bail from a research and policy perspective now for some time, starting in earnest back, I would say in 2011, 2012, when we were contracted to evaluate the bail program across the province. And at that time, we were able to gather a wealth of information of upwards of 330 case files about clients who are under bail supervision. So we got information on the personal challenges they were facing in their life. We got information on all the bail conditions that they had, and we were able to follow, in most cases, how they fared while on bail, and whether or not the bail conditions that they had were at all related to the various issues they presented with. And so our findings and our report basically culminated in the report Reasonable Bail in 2013, in which we really it showcased, I think, what everyone knows, in that there was such a high prevalence of mental health issues, substance use issues, concurrent disorders, homelessness among those under bail supervision at the time. And we were also able to identify that a number of the bail conditions that were being imposed on individuals who were already marginalized were not really at all tied to statutory grounds for bail, or even not necessarily had a nexus with the allegations that people were being charged or that were being alleged. And so really just more around behavior modification. Some were sort of just punitive. And so our recommendations really focused on the need to return to the latter principle and exercising restraint in terms of application of bail conditions. So obviously since then, we've had so many Supreme Court decisions. We've had the great CCLA report. So, we've seen, in a way, policymakers pay attention to the issue of bail in a way that sort of hadn't been happening like 10 years ago, right? So at least it was on the agendas. I will agree and concur with others that a lot of work still has to be done. And I'll talk a little bit now, and then we can talk more about it in the Q&As. But I do see one way that research can support the work of lawyers is to continue to sort of challenge and unpack some common prevailing cultural assumptions in bail courts. If in the Zora decision, the Supreme Court pointed out that a condition must attenuate a risk that would otherwise prevent release without that condition. And then they later say the conditions must be sufficiently linked to the defined statutory risks. So in the discourse on bail and bail reform, concerns about imposition of bail conditions tend to be framed justifiably in the context of the infringement that they place on people's civil liberties and the presumption of innocence. But I would also suggest that another way to look at these things is the commonly applied bail conditions that seem to be, continue to be imposed. Are, even if they're statutorily justified, or you can argue that there is a relationship to the grounds for bail, are they actually mitigating or attenuating risk? So questions like, I think culturally, courts might take for granted that certain types of bail conditions actually give rise to greater safety and address or mitigate secondary grounds concerns. But is there any evidence or compelling research to suggest that that is the case? And so I guess collectively, I think we need to do a better job, attacking those prevailing assumptions. So types of conditions that come to my mind that are sort of in this category could be things like curfews, no-go zones. I'm not sure how commonly abstain alcohol, abstain drug use types of conditions are still being imposed, but things like this, are there studies that actually empirically demonstrate that these types of conditions are in fact mitigating risk? Because if they're not, then I think that's just another feather in the cap of, or another tool, I guess, in the toolkit of lawyers, litigators who are challenging unreasonable bail conditions. And I think, so I guess organizations like JHS and others who are doing this research, I think we really need to start scrutinizing some really commonly held beliefs that are sort of generating and perpetuating this over-conditioning of individuals. Anyway, so I'll stop there. I know I'm at time. Happy to unpack any of those things, and I have a number of other things to say, but I'll stop there.
Thank you.
Great, thank you, Jacqueline. Okay, wonderful. Well, thank you for all our panelists for giving us their 5-minute deep dive. And so now we're going to open it up to questions. I have a few questions in my moderator sheet, and then we'll start taking audience questions as well. So one of the first questions I wanted to ask was around, maybe it's actually probably a natural follow-up from what Jacqueline was talking about, which is it's very well established that there's a culture of risk aversion, right? But it doesn't seem that this actually is factually has any basis. It's really a risk aversion to public perceptions, right? And I wanted to share this this kind of poster that we had put together for this kind of bail in the media and the narratives that stakeholders like, politicians, but also crowns and JOPs are concerned with. I'm interested to hear from the panelists is, this seems like this cultural narrative hasn't changed, and is there a way that you see forwards that this could shift, and how might we go about that?
Avery, can you go back to the very beginning of that, the sentence of the question, like which narrative in particular are you wanting us to comment on? Yeah, good clarification. So the narrative is one where basically the way that bail is presented in the media. So it's either often a doom and gloom story, like this is terrible system, it's never going to improve, these are all the outrageous things that are happening, or someone commits an offense while on bail, bail's a joke, we need to tighten up the system, guns and gangs, that kind of stuff. These two opposing narratives, and in our media analysis, these are kind of the messages that the public sees.
So I'll take a first stab. I can think of one time, that's itself problematic, but one time when there was a very high profile crime committed by someone who was out on bail, and Kirk Macon was at the time the Globe's crime and justice reporter, the main one, and he wrote like a 2-page spread about problems in the bail system. But so it can happen that you get much more, even in response to those flashpoint stories. I think you can see those narratives, and certainly after we released our report, after GHSO releases their report, after some Supreme Court judgments, you do see alternative narratives about bail coming forward. But it is a hard battle when you get those events where there's somebody out on bail and a crime is alleged to have happened, right? That is a really hard time to try and shift the public narrative. And from my perspective, I think actually it's our leadership, it's politicians, it's justice actors that need to be braver in those moments and need to take on a leadership role and an education role about what the bail system is actually about, and presumption of innocence, and the reason that there are going to be things that happen after people are released on bail, just like there are things that happen when people are not released on bail or not involved in the criminal justice system at all, right? So and we have seen lots of examples of that in Canada, less so in the past 10 years, I'll say, especially at the federal level with the previous Harper government. But, it can happen. It can happen again. The culture that I'm mainly concerned about, and I know it's separate from the culture that you're working on in your project, but I'm mostly concerned about the court actors and what's happening in the bail court, because I see that as actually the most directly impactful culture in terms of actual bail outcomes.
Thanks, Abby. I think maybe one way to connect this promise to what you had been speaking about this approach to a tertiary ground is again, connecting this public perceptions, this groundswell of, I feel like, attention being played to the systemic racism that Indigenous people suffer in Canada, and connecting that to court actors. How do you see that as a plausible or potential pathway?
Like with respect to changing the public's mind or getting the public to understand how, maybe can you just rephrase that?
Yeah, sure. So, I guess my thinking here is that you were mentioning that it would shock the conscience of a member of the public right? But this is our understanding that the public is actually more aware and engaged in understanding systemic racism, right? But then the court needs to take notice of that. So it's kind of I feel like that this doctrinal issue that you were talking about is almost exactly talking about this junction of where does the public stand and how does the court's culture incorporate, the public perceptions.
Yeah, and I think those are evolving issues, and they also sometimes are like jurisdiction specific. For example, firearm offenses in Toronto are a really big deal, and you're going to have to get a special bail hearing for many cases to try to get your client out on bail. Up north, everybody has a firearm, and firearm offenses, for the most part, aren't met with the same level of like immediate fear or seriousness. It's different. And so in the same way, like the courts are sort of trying often to reflect the concerns or not of the public. And right now, the public is far more aware of systemic racism than it has been in the past. I think it's fair to say that. So I think, like, I have made this argument as many times in the last couple of years that I had an Indigenous person who was facing a tertiary ground like detention. And nobody has really commented on it. There was one judge who said, like, that's an interesting argument, but didn't really opine on it. And I think for the most part, they're just not comfortable commenting on that.
Mm-hmm.
And I think it's fair to say, like, I could bring with me a whole bunch of, newspaper articles and blogs and stuff to show that the public cares about the treatment of Indigenous people and over incarceration and stuff like that. But I don't think that if a jurist is going to detain my client on concerns like that are rising to the level of tertiary ground, I don't think that a general, media article is going to convince them, because that's not specific to like the issue that we're arguing in court. But I think in general what it is an aversion to addressing the like real issues of colonialism and over incarceration rates of Indigenous people, because like decision makers want to disassociate themselves from oppression. They want to detach themselves from any notion that they're participating in an oppressive system. And so, like they don't even turn their mind or make a decision about the argument, because like they would have to acknowledge that the system is discriminatory in the bail context, and that it's possible that they, by detaining that person, they may be participating in like an oppressive pattern of decisions. And they don't want to do that because that's uncomfortable. So I think that's more the issue, is that decision makers who are all in positions of privilege and power, clearly they're in the position to make these decisions. And unfortunately for our communities, there's not a ton of Indigenous people who are in these positions of power and who have the power to make these calls. There's a lot of people who are non-Indigenous with privilege and power who are being asked to make decisions that require like an acknowledgement of an oppressive system, and they're decision makers in the system. So they have power in that system and they're uncomfortable with that. So rather ignore it and then move on. And like ignoring oppression is oppressive, right? Like if you're neutral if you're neutral in that situation, this is what everybody on social media has been telling us, regurgitating quotes that they've read from Desmond Tutu and stuff like this.
Right.
And I'm not saying that judges and JPs are oppressive because they ignored my argument. That's not what I'm saying.
Right. Of course. Mm-hmm.
But it is an issue when consistently people in positions of privilege and power are ignoring the hard issues and not making individual decisions about it, because that is how like oppression perpetuates, and that's how there's a culture of complacency toward addressing like colonial like issues, right? But, and I'll just wrap up with this, one like barrier to holding people responsible for doing more is like the Supreme Court has only told us that sentencing judges are required to apply GLADU. Like the Supreme Court has not taken the opportunity to make a decision and say that like GLADU principles or remedial actions or the code should be interpreted in a particular way to address over incarceration. Like they haven't done that in any other context. There's other courts that have extended the GLADU principles to other things like contempt, extradition, things like this, right? But when it comes to bail, like it was a case that I tried to bring up to the Supreme Court and ask the Supreme Court to make a decision about like bail as it applies to Indigenous people, because Antic and Myers were both silent on this. And the courts across the country are misapplying it and also inconsistently applying it. And there's two provinces where decisions have been made by courts saying GLADU does not apply. The Supreme Court does not say GLADU applies to bail. So there's that issue. And then the like Supreme Court in Anderson said you can't attack Crown discretion, and also and so in doing that you can't require the Crowns to be the ones responsible for applying GLADU principles. And so that's the other problem, is that was a decision a couple of years ago. So told by the Supreme Court, like that's not the appropriate place to address, right? And so still we've been told that the appropriate place is sentencing, because in Kokoponis, the court also said jury roles and the jury system is not the place to address systemic racism. They said that was another lost opportunity.
Right. Thank you, Promise. Boris, I was hoping maybe you could weigh in here a bit, because I mean, in our conversation beforehand, we talked about, you know, Crown decision making, and Promise brought up Anderson, and we talked about the really the inability to hold Crowns that are maybe not following procedures to account, really.
Yeah, I mean that's a really tough thing to review with the benefit of the rear view mirror. And I want to just sort of combine this question, if I may, with the previous conversation we've had. And one of the difficulties about whether it's with Indigenous persons or other groups who have been historically disadvantaged and overrepresented in the criminal justice system, it's very difficult to apply macro policy to individual cases. It is very difficult to stand up in front of a judge and say, I have an Indigenous or a Black accused who comes from a particular background, and yes, he's got a 4-page record for repeated violent offenses committed while on bail each time, but I want you to overlook that and let him out because it's not a risk. It's a very difficult argument to make, and I'm not sure that we should be relying on bail court judges to make those kinds of changes. I think those kinds of bail policy changes have to come from above, whether it's from the Supreme Court of Canada through meaningful obiter in cases where they talk about bail policy to guide the lower courts, or perhaps through either politicians or attorney generals and those in leadership positions that set bail policy for how Crowns should be following. And I specifically mentioned Crowns in this because Crowns follow a bail policy manual, so it would be a courageous decision for example, an attorney general to set out bail policy that is consistent and faithful to the issues that Promise is very correctly raised. I think leaving it to individual judges and individual cases is a big ask, and one that I don't think that we're ready for. I have my real doubts about that. Accountability, which is your question, you know, that's where the media side of it comes in, because we should not be. I want to say two things about this. Number one, the media narrative plays to the public primarily. So the media talks about the revolving door of bail and all that kind of stuff. It informs public opinion. But I mean, for the most part, my response is a combination of so what because it's not the public that makes the decision, and a need for some kind of attempt to try to change the narrative slightly. Because I tell you, you're never going to get everybody in the public to agree with this. You're never going to get a majority of the people in the public. But the narrative, it's very hard to get the media to write stories about how 98% or whatever it is, percent of people who are charged with domestic violence offenses do not commit another offense while they're on bail. It's just not a story. The media likes to write stories about when people get arrested, not when they're even convicted, unless it's a very unusual case. The story is at the time of arrest, and the time of bail is closely tied to the time of arrest. By the time that people get to trial, media doesn't care all that much about reporting it for most cases, maybe only the most serious ones, and they certainly don't care about reporting acquittals down the road or withdrawals of charges or anything else. So the front end is what forms public opinion. And I think, there was a quote, I think Sam Goldstein in the Q&A just made a comment about how we've had some colossal failures. And that's true. I mean, we've had examples of people, and domestic violence is the big flashpoint, where you had people in very high profile cases commit murder while out on bail, commit domestic violence murder, which are obviously horrible tragedies. But I think we need to have the courage to stand up and say that our system, by and large, when it comes to recidivism, is an overwhelming success. It's not a failure. To expect 100% success is foolish. For anybody that truly understands anything about criminal justice policy or we can't. The only way we're ever going to achieve 100% success is if we jail everybody for life the moment they get arrested. And so the moment we choose to decide that we're going to release at least one person on bail, we're already bringing risk into the system. And the fact that we've had the occasional disaster should not be a basis to throw out the baby with the bathwater. It should be an opportunity for us to recognize that there is risk inherent in the system and to celebrate the fact that we've only had 3 high-profile cases out of thousands, out of tens of thousands of cases. The statistical odds are enormously minute, but nobody reports the story that way because it's just not that interesting. So we need to change attitudes to the public if we can. I think it's a big ask. So if we're going to change policy, I think it has to come from the Supreme Court or from leadership in the Crown's office through Crown policy.
Can I just add to one thing Boris just said? So, because I completely agree, and you can even expand on that further, right? The real, if you think about risk, the risk that the immediate risk of releasing somebody on bail is that they go out and commit a crime. But the truth is, when we are putting people into pretrial detention, when we are putting people into jail, when we are processing through the system, we are infinitely increasing risk to public safety by putting them through a very traumatic jailing experience, right? When you take someone away from their family, when you interrupt their medication, when you make them lose their housing because they're spending, days, weeks, months, that is profoundly risky. When you think about the impacts it has on individuals, families, children's lives. So when you actually step back and say, how is this system contributing to public safety and risk to public safety? I think that is the much more holistic and really powerful narrative here, at least for me, is that, maybe, if we lock the person up, perhaps they're not going to do something, but profound impacts to public safety from the decision to lock the person up.
Right. Thank you, Abby.
But just to pick up on that, if I may, very briefly, Avery, it doesn't allow, our criminal justice system likes to find scapegoats for problems. And the difficulty with going with a holistic approach is that you lose the ability to scapegoat, you lose the ability to blame somebody. So when crowns take risk-averse positions, they do that because they don't want to be on the receiving end of some criticism because something went wrong or unexpectedly and horribly wrong. And while I do not favor, I don't want to introduce a new area, and I don't favor algorithmic solutions to bail for many other reasons, the one advantage that it would have is that it would shield the decision maker from having to be scapegoated if something went wrong. And that is perhaps the only good thing about that if it was ever introduced. So unfortunately, the way that our criminal justice works together with the public reporting on it by the mainstream media, and I'm going to get into social media, that creates risk aversion because they don't want to do something that will then end up with blowback. And I don't know how we change the narrative, but we need to try to find some steps to do that.
Right. Thank you, Boris. Oh, sorry. Yeah, I jumped in there, I promise. Yeah.
So on the topic of crowns and people not wanting to make decisions so they're not the scapegoat, I do think that like we're entering an era where I would like to see more crowns like stepping up and making bolder decisions. I think like aside from, I totally understand when it's in a domestic situation where nobody wants to be the person to release the person who goes out and like murders their partner. I understand that. Setting those incidences aside, I think too often crowns take a position to seek detention or oppose release because it's a safe bet, but it's not like it's going to cause any particular harm if the person is released. I think in a lot of cases, crowns know that if it goes to a hearing, the person's going to get released, but to protect themselves or to make a right decision that's going to get them hired back again, like I see often crowns are doing this, and this clogs up bail courts because then we have to wait 4 or 5 days for a bail hearing. And in other cases, crowns will say, well, I'll release your guy to a surety, but if not, then we're seeking the detention. And that's actually not accurate. If you think the person's releasable, then they're releasable. But then the crowns are coming to the bail court and they're saying like, we're opposing release, but actually they're not opposing release. They actually think the person is releasable, but they want us to meet them on their terms, which aren't necessary. So then you have like somebody who's actually releasable now going to wait like more days to get a hearing. And I think in those cases, like crowns should be doing more to acknowledge the real issues that we have going on and their role in the justice system, and to like do a little bit more to minimize the harm. Like, really, I think that like I'm calling on crowns to do a little bit more.
Right. Thank you, Promise. Okay, so I wanted to just pivot angles a little bit. I think this is actually a natural extension of this theme, though. So in 2019, December, Cheryl Webster and Anthony Dube published an article in Policy Options about the success of the Youth Criminal Justice Act. So in the early 2010s, there was a major overhaul of the Youth Criminal Justice Act. And several of the panelists, specifically Jacqueline, has done a lot of work now, or John Howard has done work on youth bail, looking into that. And I think just to kind of preface it for the audience, the YCGA, to my understanding, removed the certain kinds of discretion that we'd be talking about. So they would have made it, the principles of the YCGA is kind of like an ethic of care, right? Like right now we have this in the bail system, concerns around risk, right? But if you kind of transition to a culture of like care and understanding that these people are all growing people, you know, we treat youth very differently, and that a lot of these lessons could be applied to the adult bail system through similar legislation. Jacqueline, I was wondering if you could weigh in on that view.
Yeah, absolutely. So so as Avery mentioned or alluded, we've been working on a youth bail report now for some time, which will be coming out really soon, actually. So we've had a ton of youth data from corrections as well as Attorney General that we've been looking at, and also studying the successes of the YCJA. And I think the bottom line is that the YCJA has been a resounding success in terms of reducing what were some of the highest rates of youth incarceration in the world down to, much lower levels today. There are still, I think, not to give away our report, but like our findings will basically show that while there are still differential impacts and benefits, and there's certain populations who have benefited more from the impacts of the YCJA, like racialized populations have not benefited as much as others. Overall, the tone and the reset, as Abby sort of mentioned in her opening remarks around what the YCJA did for youth justice and youth incarceration, is something that I think is what advocates were hoping for in terms of what Bill C-75 was going to do. So basically, looking at the legislation, starting over and basically putting restraint as like the guiding principle, restraint in the use of incarceration So, I mean, I guess I would just say that I think there are lessons to be gleaned, a lot of lessons to be gleaned from the YCJA and the successes it has had, and that could be applied on the adult side. The one thing I would say, and it's sort of picking up on themes earlier too, on the youth side of things, when it comes to remand pretrial detention, in the youth system, young people are not supposed to be detained pretrial for welfare reasons. And so what you hear anecdotally oftentimes in youth bail stage is that it might take a few days for youth to be released because even though they are, quote, releasable, or they're deemed to be safe to be released, they might not have suitable home arrangements. They can't go back home. It's not safe. And so, you know, the Crown or the courts will hold that person until suitable arrangements can be found. And I think the analogy I guess my point is I have some sympathy for Crowns, both on the youth and the adult side, in the sense that so many of the people who are incarcerated and cycling in and out of our courts, both at the youth and adult stage, they have so many challenges. We know, like the John Howard Societies, we're serving these clients every day. They have such complex needs. Most of them are presenting with, you know, concurrent disorders, if not just substance use issues. And so I think in some cases, courts are, you know, if the person has been detained by police and they're seeing this individual and they're saying this person has no fixed address, you know, in some ways I understand why Crowns or courts will want to satisfy themselves that at least this person has some sort of like plan so that they can, you know, if they need to proceed through the bail process. But on the flip side, I guess my argument would be, to me, this speaks to the need for just upstream solutions. So these people need not be detained in the first place, right? So ultimately, I think if we're talking about global solutions and holistic looks at bail, both for youth and adult side, I think we need to look at why are these people coming into repeat contact with the justice system to begin with? Because if we're trying to fix these people's social problems at the criminal justice stage through, you know, plans of care and things like that, like it's not going to happen. And so we need better housing, we need better upstream solutions, and we need better diversion at the police stage and more guidance for police in terms of releasing people so that they're not being held for bail hearing because they have no place to go, because they need mental health supports and they're concerned about attendance of court and things like that.
Great, thanks, Jacqueline. Sorry, I just, Abby, do you want to jump in there? Sorry, I saw you wrote me a message, but I couldn't read it yet.
Yeah,
just
okay.
Jump in there. Yeah.
I was just telling Avery that there's really great questions in the Q&A. And I have so many things to say about them. So, and I imagine our other panelists do as well.
Yeah.
But I just choose, I think there was an early on question about the role of defense counsel. We've talked quite a bit about Crowns, some about judiciary. So I think defense counsel have an enormous opportunity. Boris definitely has had an enormous impact on bail and thinking about systemic ways to challenge what bail looks like through litigation. You know, a lot of this does in many areas across the country come down to duty counsel who are there day in, day out in the grind. Like, man, that is a really, really hard job in many ways. I do though think that duty counsel have room to do more, and it takes bravery because you are in that same court with those same people every day, right? But like stating on record again and again and again and again when things don't go according to the law, when decisions are being made that are contrary to precedent, putting that on the record, even if you know it is futile, not consenting to adjournments that you know are going to happen because they always happen, right? Don't consent to that and put it on the record that you do not consent, even though it is a policy and it happens every single day at 4:30 or whatever. And then defense counsel need to look at the records of how their clients were treated in the bail process. When they are looking at how to proceed with cases, it is, I think, easy to overlook. It is a pain to get transcripts. Oftentimes accused are not going to know how they were treated in the bail process, because who on earth can decipher that out? And lots of times counsel weren't there, right? So it is difficult, but I think there are all kinds of remedies and really powerful litigation tools if we just start looking a little bit more carefully, and it does, I acknowledge that it is hard, but you need to do the bail reviews, you need to put stuff on record, and then you need to pursue remedies for clients repeatedly. And I think defense counsel can absolutely do that.
Thanks, Abby. Does anyone else want to weigh in on that one? No?
Well, I agree.
Yeah.
I mean, I've done it, and I agree. And all I'll say, I mean, there are two different things here. One, for duty counsel, absolutely, it takes courage, and it's easy for me to say sitting in a different room than you are, but it's something that I'm hoping everybody can do. It is, after all, you're there to protect the accused, and 99% of the time, duty counsel are very conscious of that. They really are doing what they can to protect the accused. But there are times when duty counsel do things out of convenience and try to help the court. And if you have to choose between helping the court and helping the accused, you should choose to help the accused. So that's the one that is hard. With private counsel, those that want to pursue remedies, it's something that most lawyers rarely look at. But I caution you that if you're going to do it, you've got to get a good record. The whole key from the history of the litigation when it comes to these bail issues is if you don't have a good record, you're going to fail. And getting a good record put together is not easy. It's time consuming, and you better, the expression in for a penny, in for a pound. You got to be ready to be in for a pound. So it can be very rewarding. It's very eye-opening, but if you're going to do it right.
Right. Thanks, Boris. I wanted to take one more audience question here. Sorry, not one more, but another audience question. Efforts. Okay, so police are the gatekeepers of the bail process in Ontario. We don't have we don't have extensive charge screening. We have a few embedded crowns, but unlike Quebec and BC, we don't have charge screening. So this anonymous attendee is asking, what efforts have been done to reforming the approach to bail by police, given that they opened the door to bail court. I mean, my understanding in some conversations with you, with the panelists, was that police have been releasing more people, but I'm sure there are still quite a few challenges that remain. Someone want to speak to that?
I can take a short stab at it. Part of it is part of it's been fixed because there were undoubtedly some of the reasons why people are being held was because of the old system with warrants being endorsed or not being endorsed appropriately, and that has now been fixed through practices and through some legislative change. So that should no longer be an impediment for people being held. Really, it starts with the police at the top of the food chain. So those police officers at the top have to send the message loudly and clearly to the rank and file that they will be supported if they make a decision that ends badly, because that's always the big fear. So if police officers will know that their bosses will have their backs, then I think they'll be empowered to make the right decision. And what we've also seen through the pandemic is strong messages from the top will get results, because there has been absolutely clear direction from the leadership of the various police forces, at least in Ontario, to encourage officers to release, to get the people out, and that's led to noticeable results. So it really has to start at the top. I don't know that there's much more that you can do. If you're defense counsel, I suppose one of the things you can do is send emails to protect the record to the accused. So if you're a private counsel and you get information that your client's been arrested, and you're dealing with an officer and they're contemplating releasing or not releasing, send an email. And if there's no good reason that you can think of for this person to be held for a bail hearing, put it in writing and make it clear that you believe, and maybe that will have some minimal impact on the police officer. I know it has in a couple of cases I've done, to actually convince them to let the people out, whether it's because they're worried that I'm using this to paper the matter, which I am, for potential future litigation, or whether it's just because I've managed to convince them through my written advocacy. Either way, sometimes that's worth an effort, and it's worked a couple times, not always, but that may be something you might think about.
Thanks, Boris. Does anyone else want to weigh in on police behavior and practices?
And just to say that it's all tied with the larger, really great ongoing conversations we have about defunding the police, detasking the police, abolishing, all basically getting people out of the criminal justice system and into other more effective types of emergency responses and supports, right? So that's the same conversation. Police are largely, their decisions on release, at least from the research perspective, are largely hidden, right? We sit in bail court. It's very hard to get data about police releases. There's a few studies, suggestions that they are increasing the detention in the long term. That's the general trend. I think it has absolutely changed with COVID. But that's part of the reason there hasn't been a lot of attention on police releases, is because we can't sit and monitor them in the same way that we can sit in bail courts and get the data about what's going on.
Right. Thanks, Abby. Does anyone want to speak to overcharging? In our, if you guys check out the Law and Design Collab social media page, we put up a couple posts about overcharging. There was a recent Human Rights Commission report from a couple U of T researchers with Toronto police data, and they found some very disturbing trends for overcharging. I'm just wondering, in your kind of practice and experience, how does that factor in the bail system?
I can respond. So Indigenous people and other marginalized members of our communities are disproportionately overcharged, and especially Indigenous people. And it really screws people over for bail, for sure, because you have often like a justice of the peace is very concerned by a long laundry list of offenses that, if maybe there's an assertion that there's a firearm involved, and then there's like 5 different lines on the docket that have the word firearm involved. That is, it puts people's backs up. And a big issue that overcharging is like creating a larger detriment to people who are in custody. Recently, I see is like sort of the issues are paired with the fact that the prelims have been taken away. So when people are overcharged, if they initially would have been able to have a prelim, at the prelim, charges would be like, there would be charges that would be sort of dismissed at that point, and then only the charges where there's evidence to go to trial would go on. And often at that time, a person who had been detained could be released on bail because the strength of the Crown's case and the reality of the case is far more like evident. A problem that we have now is that because a lot of offenses no longer are eligible for a prelim, some positions courts have taken mean the court can only, one second, I have to plug my computer in before it dies. The court can only make a decision at a prelim about the charges that are prelim eligible. So that means the person, one second, my computer will die. That means the person, let me start over, just one second. I'm gonna make a really good point, I promise. Okay, so if the person's overcharged, they have like 10, 15 charges, let's say, and only the ones that are prelim eligible can be decided by a court. So you may have like one serious charge, let's say, that's using a firearm in the course of an indictable offense. But the judge can only hear evidence and make a decision on the like whether this is going to go on to trial on that one offense, and all the other offenses have to just like stay there. So even if the person, like regardless of whether or not that one offense that's prelim eligible goes on to trial or not, the other offenses are like the person stuck with all of those offenses, and then they carry on. So now with the lack of ability of prelims, there isn't an ability for the court to make an assessment about like the reality of the case in full, because the court isn't in a position to hear evidence and make a determination about the strength of the case on all of the charges. So this happened to an Indigenous client of mine, and the prelim stage was very frustrating because he had a firearm charge, but he had like 16 charges, and a bunch of them were completely bogus. And the judge at the prelim stage made the decision as a surprise to both myself and the Crown that they could not make a determination about like all of the charges that he was overcharged with. And so he was stuck with that. So overcharging already creates a problem for people at bail because their case looks just so much worse. It's really stigmatic, it's traumatic. But now with the lack of ability for people to have prelims for so many offenses, it's actually, if the person doesn't get bail, like it can serve to keep them in custody far longer than they may have been in custody before the prelim law changed.
Right. Thank you, Promise. I wanted to follow up with a kind of a two-parter to Jacqueline, which is the first being, so Promise, speaking to prelims, right? There's also the pre-charge screening. Like we have I think there's two Ottawa and Toronto, there's pre-charge screening embedded Crown program. So Jacqueline, that was part of the John Howard's budget submissions last year to the provincial government to expand funding for that. But so if you want to speak to that, that's one thing. But I guess the pivot here was an anonymous attendee here asking if the data could be captured on police release during the pandemic to show that this trend has not negatively affected administration of justice, could it possibly use to change the culture of detention? So okay, to generalize that question a bit, and I think this is a theme that we spoke to, the role of data in transforming this system and holding people accountable. I know that John Howard has access to a lot of data, and you also know what the province is trying to do with data.
Yeah, well, to your point about pre-charge screening, yeah, our pre-budget submission, I think we looked at the idea of the embedded crowns, and I think further, I think it's worth exploring things like, BC's model of pre-charge approval and pre-charge screening. And so I think that would take away, like if you think about how many people are entering into our courts with either the overcharging or too many charges, or, that end up ultimately getting withdrawn later on, but after languishing either in courts or in pretrial detention for so many days, if we could just avoid even a percentage of that upfront, I think it's worth exploring even on a pilot basis, that sort of pre-charge approval or models that exist elsewhere. But in terms of the role of data, I think your point is absolutely right. And I think I saw somebody asking questions around, especially around racialized populations, like there was a commitment in government, there's legislation around the collection of race-based data. We need better race-based data at the court and at the correction stage so that we can see how decisions are impacting different groups and tracking that better. And I think in terms of and I do think, organizations like JHS and others, if we can start trying to study and get at some of these questions and try and, ourselves create that data if it's not forthcoming from public facing or from the government, I think that's the role that we have to play in terms of working in partnership and in collaboration with those who would litigate cases and ensuring that evidence gets into the hands of policymakers. Yeah.
Great. Does anyone else want to speak to the role of data? Because this is a big one.
I have a question. Assuming our clients give permission to share data about them, why aren't defense lawyers providing that information to somewhere to get an actual representation of what's happening to people? Example, the police release stuff, we would be able to tell you how many of our clients were released by police because if they were released on a promise to appear, we would know that, right? So if there was an anonymous, has that ever been done? I don't know, not in my lifetime, Boris.
Well, the majority of people who go through the system are self-represented, so you'll never collect that data through defense counsel. It's just, it's too massive and the numbers are too high. But to pick up on Jacqueline's point, if we had the data, I think there could definitely be advocacy at the policy levels. And frankly, I think that is the kind of thing that could be used to convince the people who make those decisions on policy to change the policy. If you can show the police that they can save, forget about what's doing what's right. I mean, maybe I'm a little bit too old and naive, or not naive, but maybe I'm too old and been through too many windmill tilting exercises that for me, if you're trying to appeal for them to do the right thing, that's got a much lower chance of success than if you're trying to appeal to them to save a lot of money. So if you go to the meeting, say you could save a lot of resources through having to spend much less time and money using police officers to transport people to and from courts, using your court cells for this purpose. We can save a lot of money. You can hire more officers or do more with your budget or whatever it is. I'm not even talking about defunding aspects of it. I'm just saying, like we can make your dollar go a lot farther. I think that will resonate. And if you can do that without sacrificing public safety, then that's the pitch that has a chance of success, not the you should do it because it's the right thing to do in charter and so on. Okay, that's not going to work.
And just to follow up, Boris, I'd encourage the audience to check out some of the bail reform initiatives in the US. I don't think you're tilting at windmills. It's fascinating, the politics there. Criminal justice reform is a bipartisan issue in the US. I mean, I know the scale of their problem is off the charts, so the money argument is magnitudes larger. But just the fact that there was bipartisan consensus on that is kind of fascinating. So we're coming out to running out of time here. Boris, did you want to speak to that question by Michael Bryant?
Yeah, I've answered it partly.
Yeah, could you actually rephrase the question for the audience?
So Michael asked about whether or not there's he thought one of my thoughts about the suggestion that some defense counsel take the path of least resistance by agreeing to take up consent bail offers so that they don't have to stick around courts all day. And then suggesting that maybe should lead to a more efficiency by using duty counsel who are paid for the day in any event. I get a little protective of defense counsel, although I'm not shy about blaming them for problems with bail. I think this isn't one of them. Frankly, most defense lawyers aren't in it for the money. I think there are definitely going to be some who will take the path of least resistance because of money, although I think that's probably a small minority. I think what it comes down to is not your choice is not so much to get more money or more money more quickly. It's to make sure that your client gets dealt with that day. It ties into the bigger problem of bail delay. So while a defense lawyer or a duty counsel may agree to terms of bail that are being proposed as a consent by the Crown, is usually tied to the fact that they don't have another option that day that's really viable. So it's do I risk having to spend the night in jail, or can I live with these conditions? And almost always the answer is going to be, I don't want to risk not being reached, or perhaps not being reached for days. So I'll take what I can get and get out of Dodge because I'm worried about what the alternatives are. And this is why out of the box ideas, we haven't talked about something like interim bail, but out of the box ideas are needed so that the leverage changes. And when all the leverage is in the hands of the Crown that says your choices are agree to this or spend a day or more in jail, you lose your job, you lose this, you lose that, then the leverage isn't in the right spot. If we had a system where people waited out of custody for their bail hearing that didn't get reached, then all of a sudden Crowns would start acting more reasonably on their bail positions because the leverage would be different. So it's a negotiation. And I think to finish the answer, duty counsel would be similarly, not for money reasons, but they would be similarly motivated to take less than ideal bail resolutions because they are trying to get 30 or 40 people out of bail court that day. And they know that if they hold up the process for one, trying to get a better bail condition, that may make 10 people not get reached that day. And so they may try to take a holistic view and say, I'm going to help everybody that I can. I'm going to consent to crappier terms. We're going to get all of them through. So it's complicated, and it's tied to really power and leverage.
Right. Thank you, Boris, for that answer. Yeah, we have 30. Can you do it 30 seconds?
Yeah.
Okay, cool.
Another issue is that if you don't agree to the Crown's positions and their conditions, some Crowns will then say, okay, then this is a contested hearing, even though you're going to only argue about a curfew. Then they'll put on the record to the court that it's a contested hearing. And then the court will hear it's a contested hearing and it goes at the bottom of the line. And then the client is then freaking out because they're not going to be reached. And I don't think that's a proper way to present the issue, like to present the case to the court. And I think that results in people like freaking out and clients then panicking and then feeling like coerced into agreeing to a particular condition.
And it's just like, I think Tunney is actually a good example of ways that you can address some of these things very effectively by just tweaking the procedure, right? Like bifurcating. Anyway, so there are ways to try to balance that out, but it is fundamentally not an equal playing field, you know, even with things like Tunney.
Okay. Well,
Tunney's not addressing that.
Yeah. Okay, thanks. Thank you. Well, I'm really sorry to call time. This was such a great conversation. I want to thank the panelists so much for making time to speak with us and being so frank and full in your insights. We've had 70 people, 55, 60 on the audience here, another 10 on YouTube. Stay throughout this entire conversation. So I want to thank the audience so much for—
Yeah, and they ask a lot of questions as well. So
yeah, our very engaged audience. And please check out our website, unlockbailreform.ca. I really do hope we have continuing conversations, like a part 2, maybe a part 3 of the future of bail reform. I feel like there's a certain level of optimism and appetite for systemic change and these kind of deep conversations that has kind of come into the public sphere with the pandemic and with all these racial justice movements across the world. So please stay tuned, and please also check out all of our panelists. You can find them on Google, mentioned in the news, on social media. They're really great commentators. So that's it. That's for us today. Thank you so much for your time.
Thank you, everybody.
We'd love to hear from you. So please get in touch.
Bye.
Bye. Have a good one.
Thanks for having us. Bye, everybody.
See ya.
Bye.